There we go. And Kim Lisa Taylor is a nationally recognized corporate securities attorney, a best-selling author. She's the founder of Syndication Attorneys, a Florida-based law firm that provides security offering documents and investor marketing materials for clients nationwide. Kim has been the responsible attorney for hundreds of securities offerings and appears in the top 100 people in Finance magazine and is listed in the marquee Who's Who. And I got a copy here of her Amazon book, How to Legally Raise Private Money. So Kim, take it away.
Hey, thanks everybody for showing up today. And thank you so much for inviting me to speak to you. I'm hoping that I can impart some knowledge. I'm going to speak today about one aspect of capital raising, which is where a lot of people start, and that's with their family and friends, raising money from people that they know who believe in them and who believe in their product and want to help see them succeed. At the same time, hopefully getting a home run or at least a reasonable and nice return for themselves. So we're going to talk about the family and friends raise, and then I'm going to table the discussion on taking your company public and other ways that you might finance through angel investors and venture capitalists, I think, for a second presentation. So we'll talk about the nuts and bolts of raising money from private investors, and I'm going to go ahead and share my screen.
Doug, let me make you a co-host here. Just a minute, okay, please. Make co-host. Okay, yes. Are you able to share now?
Yep.
There we go.
And now I'm going to let me see if I've grabbed the right screen. Which screen do you see? Do you see the right one, or do you see?
I see capital raising nuts and bolts.
Very good. Okay, so we'll just try to start with that. So I am an attorney, but I'm not your attorney until we have a signed fee agreement. And as is often said in the industry, until your check clears the bank. I am the author of How to Legally Raise Private Money. It is a #1 bestseller. I'm also the founder of Syndication Attorneys, PLLC. This is primarily a real estate law firm, Syndication Attorneys, but I am in the process of setting up another company, a California law firm called Startup Securities Law. And it's really going to cater more towards people that are doing startups or small businesses that are raising money to launch a product or service. I have syndicated real estate in the past, so I have raised some money from some friends myself. And I actually have a certification as a certified capital raiser. I've been the responsible attorney for hundreds of securities offerings with over $1 billion worth of raises. And those funds have translated into buying billions of dollars worth of real estate and other types of businesses. So capital raising regulations, securities laws are the primary thing that everybody's concerned about. But the second thing, and we're not really going to touch on it very much here, is structure. And I think structure is something that we want to talk about more in the second part of the presentation. But, so your corporate structure is important, but that's something that you may already have decided what that's going to be, or you may need some help with deciding how to sell shares and what to offer and those kinds of things. But it all boils down to you have to follow securities laws if you're selling securities, and you have to be able to figure out when you're selling securities to know when you have to comply with securities laws. So the Securities Act of 1933 is what defined what securities are. It requires that anybody who's selling securities disclose all the material facts, and it imposed penalties for failure to comply. So what it said was that the offer or sale, so the offer or sale of securities must be registered unless exempt. And then we need to understand, well, what is an offer? Well, an offer is anytime you're offering something in exchange for money. All right, so you're offering something in exchange for money. It's a contractual obligation of some sort, usually in our context. And so what kind of securities are we talking about? Well, in the context of raising capital for small business or for real estate, it's usually going to be in the form of promissory notes or investment contracts. So I'm sure that some of you have heard of convertible promissory notes. This other term, investment contract, that's a little bit more elusive, but that's the one that most people do, because when does that occur? It's whenever you have an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. So in translating that into plain English, that happens when you offer passive investment opportunities to somebody where they're relying on you to generate a profit for them. So the examples of that: interest in an LLC, interest in a limited partnership, corporate shares or stock, certain tenant in common interest in the real estate context. But anytime you have some kind of a passive investment, there's a lot of other kinds of legal instruments that you could use that would meet those 4 criteria. So does someone have a question?
Yeah, actually, could you give us some examples of what is not considered a security? For example, partial shares in, let's say, a work of art. Would that constitute something that doesn't require all of the acid test prongs of the Howey test? In other words, you don't need the efforts of a manager, but is it a security or not? I can't
Well,
tell.
except that who has control of that asset, right? Somebody still has control of the asset. Somebody has identified the asset. Somebody is the one who's promoting that asset. So it could still meet all those 4 prongs. So you've got investment of money in a common enterprise. All of the investors are expecting profits, and they're expecting that the promoter is going to identify, acquire, and store, and eventually probably sell, or whatever they're going to do with that asset. So I think you still meet that test. So here's an example of what's not, though, is a joint venture. Okay, so in a joint venture, everybody's actively involved in generating their own profits. That is the distinction between a passive investor and one who's an active investor, is when the active investors are actively involved in generating their own profits. They're not looking to one person to handle all of that. So that's kind of the best example I can give you. But you can, so what is syndication? Syndication is used widely in the real estate industry, not so widely in the startup industry, but it's really, the definition does apply. It's just that the terminology is not used the same way. But it's, syndication is just organizing a group for a common purpose, to promote a common interest or to carry out a particular business transaction. And you could do that for anything. You could buy a plane, you could, buy your piece of art, you could buy a yacht, pretty much you could buy land and hold it forever. You can invest in businesses. You could do all kinds of things. You could start up a business. So again, syndication versus the joint venture, you've got the investment of money, you've got a common enterprise, you have an expectation of profits, but the investors are generating their own profits. They're not relying on somebody else. So who doesn't follow securities laws? People who don't know, people who don't care, people who are in denial, because that's the most common category. Is I meet people all the time that are selling securities, but they say they're not. They're calling it a joint venture, but they're running the show. Or there's people that, a lot of people that just don't know, and they usually find out because at some point they'll ask somebody to invest in something and someone will mention that they should, check into securities laws. People that don't care, those are people that have just, have decided we don't care, we're going to raise money any way we want. Unfortunately, I run into a lot of attorneys that they're not securities attorneys and they don't understand securities laws. And so they're either corporate attorneys or they're real estate attorneys, and they believe that all we have to do is form an LLC and sell interest in that LLC and we're good. But we've just learned that when you do that and someone else is in charge of that company, then they actually are selling securities. They just don't know it. So they're in denial, and or they're in jail, So that's so when do you need to follow securities laws? If you're raising money from passive investors, Okay, and I hear all kinds of things all the time that are these misnomers, like I'm only raising money from family and friends. Well, these exemptions that in the securities laws that I'm telling you about are specifically designed for people who are raising money from family and friends. So there is no family and friends exemption that says I don't have to do anything. It says you have to do something, you have to follow a specific set of rules. But I also hear things like, oh, I'm raising less than $1 million. Well, there's no securities law that says, well, if you're raising less than $1 million, you don't have to do anything. Or I hear I'm raising money from less than 35 people. Well, you're going to find out what these are just kind of abominations of the actual law, and they're completely incorrect that they don't have to do anything. They do have to do something. So, when do you need to follow securities laws? When you're raising money from passive investors, selling interest in a company to passive investors, repeatedly borrowing money from, and when I say borrowing private money, I'm talking about not, you're borrowing money from someone who's not in the business of loaning money. Okay, so if you're borrowing money from someone who's in the business of loaning their money, they hold themselves out as a hard money lender, or they're an institutional lender or whatever. You don't need to worry about that you're selling them securities, because they're the ones that are bound to comply with their own set of rules. When I'm talking about borrowing money, I'm talking about borrowing money from your neighbors, your family, your friends, people that you meet at conferences, those kinds of things. All right, so what does it mean to follow securities laws? It means you either have to register your offering, and that's the going public. That's your IPO, initial public offering. And that requires filing a huge pile of paperwork with securities regulators, getting their approval. And there's usually a back and forth process that goes on for about 4 to 6 months, sometimes even longer, where they're asking a bunch of questions, asking for clarification, maybe looking at background checks of all the people that are involved. And just really digging down deep into what's being offered and who's offering it, whether it's worthy of a public offering. Once you do register your offering, you're able to sell it to the public any way you want. You can advertise it, you can sell it on the NASDAQ, the New York Stock Exchange, penny stocks, any other way you want to advertise it, even on your own. But if you don't want to do that, because that's a very long and expensive process, then you need to choose an exemption from registration, and you need to document how you complied with that exemption. So the exemptions are self-executing, and that means that you don't have to, that you have to prove how you complied with the rule. And I liken this to a tax deduction, right? I can claim a tax deduction on my my IRS forms, but if the IRS comes to my house and says does an audit and wants to see how come I'm entitled to that exemption, I need to have paperwork to back that up, and I need to be able to prove it. And if I can't, then they're going to take away that deduction. They're going to say, you don't get that deduction, so you owe us taxes, you owe us penalties, and all of that. So this is the same way, is that if you're ever audited by somebody in the securities industry, then you would have to prove how you complied with that exemption. And I had an attorney just recently ask me, well, yeah, how do these audits ever occur? That's nothing that ever happens. And I said, well, here's how it happens. It doesn't happen when the deal is going good. All these documents are sitting in your drawer, nobody's complaining. But when your deal starts to tank and investors aren't getting their money back, they're not getting their returns, maybe the person they've invested with is not returning their phone calls, that's when they start complaining to the securities regulators. And it's not the SEC that's going to come after you. As near as I've been able to tell, I get these SEC bulletins. As near as I can tell, the SEC doesn't go after anybody that hasn't stolen at least $15 million, or they've gotten a huge number of complaints about that person. But every single state has its own securities division, and those state regulators are very much interested in going after these small operators that aren't complying with securities laws. So most likely, if you had a deal that started to tank and you weren't communicating with your investors, and or you were stealing money or something like that, and people were fearful that securities laws had been violated, they would go to their state securities regulator, who would then send a letter to you saying, we want to see all the documents related to this particular offering and any other offerings that you may have done in the past, whatever. So they're going to start really scrutinizing what you're doing and what you've done in the past, and maybe start interviewing some of your investors. I've seen that happen in the past, and trying to figure out whether you're following securities laws, you're not following securities laws. Is it just some technical violation that, hey, you forgot to file this form, or you forgot to do this, but you did everything else right? Or are you just flagrantly, disregarding securities laws because you either don't know, you don't care, or you're in denial? So that's usually how that happens. So, there's something we in the industry, we like to call the good deal exemption, right? Nobody complains about a good deal. And there's also the under the radar exemption, where, you don't have enough investors to really warrant getting a regulator involved in it. The other way that it happens is if one of your investors happens to pass away, and their interests get passed on to their heirs, who have really, they don't have a relationship with you. They don't know what their dad or their mom invested in. They just want the money, and they want to split it up between the 5 of them. Right. So all of a sudden they come to you and say, hey, I want my dad's money back. And you're like, sorry, can't do that. It's been spent. It's been invested. You're going to have to wait. And they don't like that answer. So they go hire an attorney, who then starts sending you threatening letters and and through, maybe files a lawsuit. Through the discovery process, they start asking you, how did you, all of your securities compliance, and if they can find a way that you may have violated securities laws, they're going to use that like a gun to your head and say, you violated securities laws, therefore you have 30 days to give not only my dad's money back, but everybody else's money. And then you're scrambling to try to replace that money, and usually it doesn't end well. So here's the securities exemptions we're talking about. These are not that hard to comply with. Usually securities exemptions, there's exemptions both at the state and the federal level. The only time you'd use a state and what's called an intrastate exemption is if everything was happening all contained in one state. You were, maybe you were buying something, or your business was located in Florida, and all of your investors are in Florida, you're in Florida, everything's contained in Florida, then you can follow the Florida intrastate exemption versus the federal exemption if you're going to be having investors crossing state lines. So you have investors from multiple states. You're going to be running a business that's going to be operating in multiple states. You're looking for funding for that business. That's the kind of thing where you would then start looking at the federal rule. And the reason that people like the federal rule is because if you pick the right one, it supersedes all of these other state laws. So you don't have to go around and say, oh, well, I've got an investor in Georgia and in Florida and New York, and now I've got to comply with all these different state laws. You can just comply with one set of rules, file notices in those states telling them that you've sold securities in their jurisdiction. They're satisfied, and you can go on your way. But typical exemptions might have a dollar limit. They could limit the number of investors. They could dictate what qualifications you have for your investors, what kind of financial qualifications they must have. They may have limited advertising or no advertising allowed. So that's kind of the hallmark of whether it's a friends and family exemption versus an advertised offering. Is if it's your friends and family, you should be able to call them versus sending out an email blast to a database of 3,000 or 5,000 people that you have never talked to before. You'll have to disclose the risks, because remember in the beginning we said you had to disclose all the material facts that investors need to make informed consent. That's always going to be a requirement whenever you're selling securities, and you may have some securities notices that you need to file. So let's, before we go much further and talk about the specific exemptions, let's talk about what qualifications might these investors have to have. Some of you may know this term, some of you may not. The term accredited means someone who has over $1 million net worth excluding any equity in their primary residence, or they have $200,000 a year income if they're single, or $300,000 if they're a couple. And a couple's income, as recently with the definition was changed, and now also includes any non-married couples who are, living together, cohabitating, acting as a couple. So you don't have to be married to qualify. But here's some exemptions that are just kind of side by side. This Regulation D Rule 506 is by far the most widely used federal exemption. There's about 25,000 of these filed every year. In 2017, the amount of money raised through Reg D exemptions exceeded the amount raised in the capital markets, and it's now exceeded it by several $billions. So private offerings are nothing to sneeze at. You look at NASDAQ, New York Stock Exchange, and all of that, and you think that's where all the money is. It's less than half of the money now, because the other half is invested in private offerings. So under Regulation D Rule 506, there's two options. There's one option that is Reg D Rule 506B. This is the original rule. It's been around since the 1980s. This was originally called the country club rule, right? So it's, three guys, or, one guy's getting together with three of his buddies, and he's going to go out and buy an apartment complex, or he's going to invest in this widget. And, they wanted a way to be able to do that without having to go through this registration process. And so this Reg D Rule 506 was born in the 1980s out of that, where they said, okay, if you're not going to advertise, you're only offering it to your friends and family, people who know you well, people you know well, then we won't make you go through all this craziness, and you can do it, but we're going to put some limits on it. And so the limits are, you can't do any kind of advertise. You have to demonstrate that you have a pre-existing substantive relationship with that person. And you can have an unlimited number of accredited investors, because we consider them to be rich and smart enough to protect themselves. And you can have up to 35 non-accredited but sophisticated investors. So these are people that have something more than just some savings and a job. They've either, educated themselves, or they have some, prior investing background or experience, or something like that. And then we're also going to require some securities notices. So there's a Form D that the SEC created that they want filed. And that has to be filed within 15 days of when an investor's funds become irrevocably contractually committed. So that usually happens when you use their money. It might not happen when they send it to you, because you might have to have it sit in your bank account for a while you're gathering funds or getting ready for whatever the investment is going to be. But the point at which they could no longer get their money back, if they came to you and said, oh my gosh, something happened, I can't do this deal, at that point, then you are required, you have 15 days to file this Form D with the SEC, telling them that you sold securities and which exemption you're claiming. And then also the states want to be notified, and mainly the states really want their fees, because the state notices have fees associated with them. So they want you to file a notice saying, I sold some securities to someone in your jurisdiction. And those fees range from nothing in Florida. All the other states are anywhere from $150 to $1,200. The most expensive is New York and Massachusetts. Most of the other states are $150 to $300, but those states, Northeast states, are more expensive. And then if you're going to have any non-accredited investors in your deal, and you're doing a 506B offering, you are required to have a private placement memorandum, and the SEC prescribes the format for this. It looks much like a prospectus for a public offering. So it follows a prescribed format that the SEC dictates. The Regulation D Rule 506 came out of the Jobs Act in 2012. The Obama administration tried to free up the capital markets when the banks weren't lending. And so they enacted the Jobs Act, and it took about a year, but out of this came Regulation D Rule 506C that said, all right, we'll allow advertising of these private offerings, but we're not going to let you advertise and include non-accredited investors. The only people that can invest in these advertised offerings are going to have to be verified accredited investors. So in the Rule 506B, the investors don't have to be verified. They can check boxes on a form saying, I meet these definition of an accredited investor, and you're allowed to take them at their word. But if you're going to do a Rule 506C offering, then you must they must go through a verification process and provide you with a letter from their investment advisor, their attorney, or someone with a license, or their CPA that can vouch for them and say, yes, indeed, they are accredited and I've reviewed their financials. So the filing requirements are the same, and you're not required to have a private placement memorandum, but in our industry, we consider this private placement memorandum to be an insurance policy because it really shifts the risk of loss from you to the investors. With the private placement memorandum, there's about 7 or 8 pages of all the different things that could go wrong that could cause these investors to lose all or part of their money. And if they read about all of that and still go ahead and subscribe to your offering, then they have accepted and assumed that risk. And so as long as you're not doing something willfully wrong or illegal or grossly negligent that causes them to lose money, then you're not going to be held responsible for that. These other two at the end are just the Florida private offering. So this is the intrastate Florida exemption, and this is the intrastate California exemption. And I use both of those. I'm licensed in both Florida and California as an attorney, so that's why I use both of those examples.
Kim, could I ask a question there?
Yes.
Have you ever seen anyone do a 506C offering without some sort of a prospectus or a PPM?
Oh yeah.
They can raise money that way. People will just give them the money.
They still need to have you still need to have something that someone's investing in. So the PPM is just one piece of the puzzle. In fact, 2 slides from now, we're going to cover what's in a securities offering. So maybe let's just move on and I can explain that. We talked a little bit about, for the Rule 506B offering, this is by far what most people use. All right. So, I think the Rule 506C offerings didn't catch on as quickly as the SEC liked. Or as the SEC expected. One of the reasons is because, there's estimates out there that only 10% of the investors that are out there are actually accredited investors. So if you decide to do a Rule 506C offering, you're going to advertise, well, you just cut out 90% of the people that might invest with you. So it really does cut you out. And all of our clients that are coming to us to either do a one-time raise or a first-time raise, you don't have any credibility with investors until you have some experience with investors. So you really, they all want to know, what have you done before? And, what's your background? And have you done this before with investors? Have you delivered? And so until you can either demonstrate some kind of a track record or with, that product, that service, that, other startups, or similar real estate, then, strangers are just not going to take you very seriously. So, what does it mean to have a pre-existing relationship for the Reg D Rule 506B offering? It means that the relationship predates your offer. And what it really does is it predates when the offering was current or contemplated. Well, current means you have offering documents in hand, you're raising money. Contemplated, in my mind, means you've hired your attorney and they're drafting your documents. Because until you've done that, you're just having a conversation with people, it's conceptual. Substantive means that you actually have to have had a conversation with that investor to determine their suitability before you made offers to them. And so generally accepted in the industry is that you want to allow some passage of time between you and you have this conversation. You talk to an investor about their financial qualifications, whether they're accredited, whether they're not accredited. If not accredited, how might they be sophisticated? How long you might be planning to hold on to their funds. Does that work within their time horizons and their plans for their future money? Those kinds of things. So you want to, make sure that you have those conversations and that you document when you had those conversations, because that really determines the beginning of the relationship. So if any of you are thinking about raising money, the thing to do is to go out to all your family and friends right now before you have offering documents in hand, start having these suitability conversations. We do have a an article on our website that, so if you go to syndicationattorneys.com into the library, there's a section that's entitled articles, and it's called, what's a substantive relationship. That article actually even has some example questions in it. And so I always recommend that people that are raising money should read that article. So what's in a securities offering? So what is it that, that we create? We're corporate securities counsel. So we don't just deal with securities compliance. We also deal with setting up the corporate structure for the company that's going to be selling the securities. So you're always going to have that PPM, that disclosure document. You won't have that if you do an you're not required to have it if you do an all accredited offering. However, we recommend it for all of our clients if you're raising money from more than just 4 or 5 accredited investors that you know very, very well. So this disclosure document, again, it's your insurance policy. So, and all of the legal fees, our legal fees are all reimbursable from your investors. So you're going to raise enough money from the investors to cover your legal expenses, in addition to all these other sources and the other uses of these funds that you might have identified. So the PPM, then typically you're going to have some kind of a contractual agreement. So it could be an operating agreement, a limited partnership agreement, a shareholders agreement, a revenue share agreement, could be a promissory note. But that is going to be the contractual agreement between you and the investor, so that if there was ever a dispute, that is the agreement that ends up in court. The PPM is just kind of a notice, right? Nobody's ever going to litigate that unless you lie in it, right? If you commit fraud or something like that. The subscription agreement. So this is kind of the opposite of the private placement memorandum. This is where the investor certifies to the sponsor, the person who's promoting this offering, that the investor is, meets the financial qualifications, is an accredited investor, and checks all the boxes that they meet those criteria. That they've read all of the documents provided by the sponsor of this offering, that they understand the risks, and that they can afford to lose the money, and they're going to go ahead and invest anyway. And here's how much. So this the PPM and the subscription agreement, those two things, I liken this to a sandwich, right? You've got the outer, you got the bread, and then you got the meat in the middle, and the meat in the middle is the contractual agreement. This investment summary, this is usually going to either be embedded in your PPM or prepared as a standalone document that's attached to the private placement memorandum as an exhibit. So the PPM is the primary document. All these other documents below it are usually exhibits to the PPM. So this investment summary is really where you're telling the story of this investment. What is it people are investing in? How is it going to generate a profit? How long is it going to take? And before that profit gets generated, what has to happen before they get their money back? And who are the team members that are promoting this offering? What are their qualifications? And then these securities notice filings we talked about a little earlier. Property information if you have a real estate deal. So there were some updates not too long ago. I don't know that any of these are really that relevant, but we'll just run through them very quickly. The accredited investor definition was recently expanded in December of 2020. There was a proposed finder's rule where you would have been able to pay someone who was not a licensed securities broker dealer a fee for referring accredited investors to your deal. That was proposed in the Trump administration, but has not been picked up in the Biden administration. So if you're interested in that, call your legislators and tell them that you want them to pick that back up. And then, so these accredited investor, the reason that they even did this was because they looked at some statistics, which I find very interesting. So over 50 million retail investor households. So what the SEC calls a retail investor is, ordinary people, versus hedge funds or private equity funds or, people who, mutual funds, groups of investors and institutional investors. So there's over 50 million retail investor households, and over 50% of the households have savings or 401ks. And the amount raised in the private offerings exceeds the amount raised in the public offerings and has since at least 2000. I actually think it started to exceed it in 2012. That was when the kind of the tipping point was. So the accredited investor new definition now includes certain people with certain securities licenses, knowledgeable employees. So if you have a knowledgeable employee that's been with you for a long time, they're understand the investment, and they're willing to invest their own money in that, then they can do, qualify without having those financial qualifications. And then the spousal equivalents, that's what they call the non-married cohabitants. But there's non-retail investors. So any company with $5 million or more in assets counts as an accredited investor. If you wanted to put your own group of investors together to invest in somebody else's deal, if all of your investors were accredited, or that LLC, say you did it in LLC, that company had $5 million or more in assets, it would be considered one accredited investor. But if you don't have $5 million in assets, the sponsor would actually have to look through your LLC to find out the qualifications of your individual members, and then they may have to count some of those people towards their 35 if they weren't accredited. Family offices is another category that was added. There's a lot of different exemptions. I've only covered a couple of them. The ones I've covered are the ones that are by far the most popular. The others are, minuscule used. They're not used very often. But there are some other exemptions. Regulation A+. This also came out of the Jobs Act, which actually allows someone to raise up to $75 million in a 12-month period. That's kind of a rolling 12-month period, so you can keep it alive and raise much more than 75 million. But this is a streamlined public offering. Takes about 6 months to get approved. And then once approved, then you can go out and you can raise money any way you want. You can, post it on the web. You can promote it in the newspaper, on the radio, on TV. And you've probably heard some radio ads. I know I hear a lot of ads for Rule 506C offerings that say they're for accredited investor only. And I also hear ads for Reg A+ offerings. So if you listen to the, really fast fine print that the announcer is reading, then you'll hear what that exemption is. Regulation crowdfunding, this also came out of the Jobs Act. And this was the rule that allowed anybody to invest no more than $2,000 in an offering. But these offerings are really designed for people who want to raise no less than $5 million. It started out as $1 million, but it was just increased to $5 million. So if the most you're ever going to have to raise is $5 million, you can do a regulation crowdfunding offering. And you have to post your offering on a registered investment portal that's registered with the SEC and FINRA, which is a self-regulatory agency for securities sales. But with Reg CF, if you want to see examples of Reg CF offerings, one of the sites that I really like is WeFunder. It's WEFUNDER, WeFunder. And if anybody has an idea or something that they want, I can send you a link so that you can get a discount off from WeFunder. If you decide to use their services, they'll give you, I think it's a $2,500 discount off their services. So if you email me, Kim@syndicationattorneys.com, I would be happy to send you that link. But also then, we help people who are doing Reg CF offerings set up their companies, because you've still got to have that meat inside the sandwich, and you still need a securities attorney or a corporate attorney to help you set that up and figure out what it is you're giving away or selling to your investors. And then there's Rule 504, which is a not very well used offering. And the reason that it's not so popular is because it requires state pre-approval, whereas the Rule 506 supersedes state law. The other thing is, let's see, where we go.
Before you go on, could I ask a question?
Of course.
So with the 504, and the state law, do you have to do blue sky compliance on every state that you offer?
Yes, with the Rule 504.
I see.
And let's just clarify what blue sky compliance is. For the Rule 506 offering, you can do blue sky compliance by just filing a notice saying, hey, we're doing a Reg D offering. And each state law says this. It says, if you're doing a Reg D offering and you follow all the rules for Reg D, and you file this notice within 15 days of sale to an investor in our state, then we will grant you the Reg D Rule 506 exemption. Rule 504 actually requires pre-approval by the states before you can sell it in their states. So you actually have to submit your offering documents and get them to approve it. Proposed finders rule. So everybody got really excited about this for a while. I can tell you that this is one of the number one questions that I get asked, and it's probably one of the major violations that I see daily in my practice, is that people pay unlicensed finders to find investors for them. They pay commissions, or they pay some kind of transaction-based funding that's related to the amount of money that they raised, and that's absolutely illegal unless the people who are getting paid those commissions have securities broker dealers licenses, which is very, very difficult to get. It's not like getting a real estate broker's license or something like that. It's like 100 times harder. That's something. So what do? We do securities offering documents, joint ventures, entity formation, pre-syndication retainers, our website. We also have another website called investormarketingmaterials.com. And the reason that we created this is because we had been telling our clients for a long, long time that they really needed professional marketing materials, and they weren't capable of finding anybody to do it on their own, and neither were we. We tried for years to find people to do it, and finally I just hired someone and trained her how to do it. And so now we have several people working for us in the investormarketingmaterials.com, but if you're interested, we can do pitch decks and educational presentations and all kinds of things there. And then we do have a podcast right now. We have one that's called Raise Private Money Legally for Real Estate, but we're planning to start another one that's called Raise Private Money Legally for Startups. So that's us. If you'd like a free digital copy of my book, Doug tried this and he found it problematic. So it's called How to Legally Raise Private Money. If you go to syndicationattorneys.com, you can get the free copy by clicking the, get the book. If you don't like that, and your other option is to buy it at Amazon, you can either get the Kindle or the soft copy version of it. And then that's us. And we do free appointments, free 30-minute consultations. I do have, as far as my staff, I've got several other attorneys working for me, as well as paralegals, law clerks, admin staff, and professional editors, graphic designers. So I'm open for questions if you guys have any.
Yeah, I got a question. Does your firm also help people start funds?
Yes, absolutely.
And so when starting a fund, does it make sense to get soft commitments from people before you actually sit down and write up the legal documents?
What we recommend is that when we do let's go back here, show you back to that slide if I can find it. So when we do a fund, and if you want to get soft commitments, then we suggest you start with the investment summary. And we would create that as a standalone document that you can go out and start showing to your investors and see if they're interested. In fact, I was on the phone for a couple hours today doing what we call a deal structuring call. So when we bring in a new client, then we sit down with them for 90 minutes to 2 hours and go through all the different choices that they have to make through their offering documents. And so I was on a call with a client today that's just starting out. They want to do a fund, but they want to start with the investment summary so that they can see if there's enough interest before they invest in the rest of the offering documents. So the investment summary, you can read more about that at investormarketingmaterials.com, but it's a 10 to 16 page document that describes your business plan. And it will kind of lay out your projections and, you know, whatever it is you need to convey to investors to answer all their questions in advance. And that's really the way to go. And once you get enough interest from people, and that's also going to be the way that, you know, that's what sells people. They're not going to get sold on reading a PPM. Nobody gets sold on reading PPM, right? If you sell them on the investment summary that's, you know, nicely professionally designed and, you know, written in plain English and very understandable and coherent, then they make their decision right then. And then when you send them the rest of the documents, they're more of a formality. But yes, that is a good idea. And that's about a $5,000 investment if you have us do it. 5,000 to 7,500, depending on how complex your you know, what it is, your investment is. You know, for a real estate offering, it's 5,000. For non-real estate offerings, it can get a little more complex, but 7,500 would be adequate for that. So, and then as far as timing, it usually takes, plan on at least, if you're doing a specified offering. So that's one thing we didn't talk about. So you can do a specified offering where you're just creating a fund for one thing, right? Or you can do what's called a blind pool, where you're creating a fund that's going to follow its own business plan to invest in multiple things. But you don't know what those things are, but you haven't identified them, but you've established some criteria in your investment summary. But the specified offering is the way that most people start, and it is also the easiest way to raise money, because when people can see and feel and, you know, get some kind of a tangible thing in front of them, they're more comfortable with investing in that than they are investing in your business plan. You know, and unfortunately, there's been some bad actors in the field that have made people a little skittish about that, that have abused those funds. And, you know, so people hear you say fund and they think of you in a Maserati and them in a Toyota, you know, you're jetting off to the Caribbean while they're, you know, driving to the beach. So.
With so many people syndicating so many different properties, how can you know which ones have a history of delivering their back-end fund administration documents on time, such as the so-called partnership K1s at the end of the year?
You can ask for some investor references.
That's a good idea.
Yeah, we have an article on our website. It's called, in fact, it's the last chapter of my book, and it's called Chapter 14, Passively Investing in Syndication. The article is actually called 10 Things Investor, and so this has a checklist, 10 questions you should ask. But the article is called 10 Things Investors Should Know Before Investing in a Syndicate. And, you know, so there's a bunch of questions here. What's the issuer's background, education, experience with similar investments? Who are the team members involved? You know, who are they hiring for their attorneys, their CPAs? When are the cash distributions paid to investors, including proposed timing and anticipated percentage returns? What fees and distributions will be paid to the issuer? What's the anticipated duration of the investment? You know, you want to look at the asset itself, whatever it is they're investing in, if it's a, you know, existing asset, if it's a business. So if you're thinking of investing in a startup, you don't want to invest at the concept stage, right? So you want to invest actually after somebody actually has some paying customers, because now they've proven their concept. All right, so the way to get get one of your own inventions funded, if you haven't yet gotten to the point where you've got some paying customers, is, you know, you go out to your family and friends who believe in you, trust you, know you, you know, raise a few $100,000, you know, get that first prototype, get some people to sign up for that, and then go on. But the further you can get from concept to implementation, the more successful your second raise is going to be. Yeah. But, and I do have a very senior attorney that's working with me who has been doing startup securities for years and years. So he was the one I was suggesting if we want to get more into talking about, the kind of the anatomy of concept to an IPO, we might want to get him involved in that conversation because I think you guys could learn a lot from him as well.
So are there any other questions? I think I've been asking all the questions.
Yeah. Hi, Kim, and hi, Doug. Bill Caltagirone here. Recently got peripherally involved in a situation that I've never been involved with, and it really concerns buying control of an ESOP, where the principal owner of the ESOP pretty much wants to monetize his investment and back off. And I have no idea what the security status of the principal investor is and what the status of the employee small holders are. If in fact I brought in family money to buy control or the larger part of the ESOP, I have no idea whatsoever, and I'm not even that deeply into this thing, but there's a great opportunity in this type of operation where it's a $20 million growing ESOP, and with a little gasoline on the fire, it could really grow maybe 5-10 years out to easily be $100 million company.
Wow, that's great. Well, I would look for an attorney that advertises that they have experience in ESOPs to help you figure out what questions to ask.
So does that mean going to Martindale Hubble, I guess?
Well, or, I often start a lot of legal research with a Google search,
Okay.
because, Google search engines are pretty sophisticated. And if you put an ESOP and an ESOP attorney, you may well find somebody that way, and you may find several people. But yeah, and you could certainly check Martindale Hubble, but I'd start with a Google search and see who's advertising that they know about that.
Yeah, interesting that you should say that, because basically to find companies, this is a completely different subject, where there is an entrepreneur who wants to retire and has a second in command, might be a family member and might be a guy who's helped him grow the company. And again, on our smaller size things, where it's 5 times pre-tax, typically, even if the guy's knocking out a couple $100,000, he doesn't have the money to put up to buy the company out. Just doing some Google searches seemed to be very productive. I'm sort of surprised because very laboriously, I have used Martindale to try to contact estate attorneys, because they're the ones who typically need to find a source of funds where they can keep a relatively small company going. And, I'm talking, 1 to 3 to 5 EBITDA, 30 to 200 employees, that type of thing, where there's not a connection with big investment bankers who could do the job.
Yeah, and just realize this, Martindale Hubble is a paid service. So in order for someone to show up on that means they have to have paid for that privilege. So I don't pay for it. And the reason I don't pay for it is because I have a strong enough presence on the web. So I don't need to.
Yeah.
And because I'm in such a specialized area of the law, that it's hard for me to find the right kind of clients that way, because I have tried some of these other similar services, and I kept getting people that were asking questions that were not on point with what I do. So I get more people off the internet. Doug, how did you find me?
Yeah, I use the Google.
There you go. There you go. We probably get 1/3 of our leads off from Google now. But
I saw your YouTube videos, and I was watching some of those as well.
Okay.
I think it was the podcasts. You have a strong social media marketing presence, and the more online stuff you do, like this, for example, the bigger your footprint is. And I think that it becomes, what they used to call guerrilla marketing but because they added the internet to guerrilla marketing, they now call growth hacking. So what you're doing by giving educational content away is you're essentially advertising for free.
Absolutely. And hopefully educating people along the way, definitely. Yeah, there's a lot of
Tim,
different ways to do it.
I've got a question. It's Mark, and we're in an unusual situation in that because we're a medical device, we're able to get government funding, and we're at about $2.5 million so far in non-dilutive funding, but it's only allowed for us to use it for clinical trials and really development in that case. So I still have to figure out when we start to commercialize how to get the money to do the commercialization aspects. And so, if we're trying to make a decision for a round of whether we go through one of these crowdfunding sites or we do something that's more of an angel investment where we're at a $1 to $2 million ask, and we still don't have that mapped out yet. But any guidance in now that these crowdfunding sites are available, which ways, what questions you're asking clients, help them determine which way to go?
Well, I would talk to the crowdfunding platforms themselves. The two biggest ones out there are WeFunder and StartEngine. My sense is that StartEngine is far more expensive to get on than WeFunder, but I don't know that for a fact. So I would do some due diligence on your own and interview both of them. I know that about a year and a half ago, when I did some research on it, WeFunder had about a third of the market. And then StartEngine came on strong with some really heavy marketing. So I'm sure they've captured some of that. But those are the two main platforms out there, I think. And there's some smaller ones that are probably capturing a small amount of the market. And usually when you sign up with one of those crowdfunding platforms, you're going to do an exclusive with them. They're not going to want you to put your stuff on both sites. So you want to pick and choose. But I don't think any of that precludes you from also concurrently looking for an angel investor. You just have to realize that what I've been teaching you about today, if you want to keep control of your company and you want to keep running it, use your family and friends. They don't want to run your company. Okay. If you want to bring in angel investors or venture capitalists, then they're going to come in and they're going to want some level of control. And, and if you need that, and if you see that as a benefit, which for a lot of people, it really is a benefit because you get that additional guidance and their expertise and, to help you launch and grow to the next level. If that's what you want, then go that way. But, you kind of have to figure out what's your trajectory.
Thank you. Yep, that sounds good.
Mm-hmm.
Kim,
Go ahead.
Kim, Bill Caltagirone here. Once money is raised there's some sort of fund, does the fund manager have to have passed Series 7 or have a brokerage license just as a manager to buy and sell in the fund portfolio, in and out of the fund portfolio?
Well, it depends what the fund is doing. Okay. If the fund is picking investments, stock market investments, yes. Okay. Because they are actually choosing investments on behalf of those fund investors. If the fund is a real estate fund, generally no, because they're going to lay out for you, here's what we're buying and here's all the criteria it has to meet. And if it meets this criteria, you've already agreed in advance that we can buy it.
And Kim, also, again, a different subject. It seems like in the last very recent times, 3 years, 5 years, there's been a tremendous confluence of basic science and medicine. And there seems to be an awful lot of potentially valuable research in universities that could end up in startups. Have you dealt with any of those things, and how have you dealt with them? How possessive are the universities of their own intellectual property?
So I'm not the right person to answer that, but I suspect that my associate, Michael Fugler, might have some insight into that.
Mm-hmm.
Mm-hmm.
Thank you.
You're welcome.
I might be able to chime in a little bit on that one, Bill. If the work is being funded in an extramural fashion, perhaps by industry or by external entrepreneurial grants, which is what I'm kind of into now. The students or the principals, I'll say, end up controlling the business and its output. So in that sense, the university, and it depends on the university too, but for Fairfield anyways, they don't attempt to attach to the intellectual property. On the other hand, if you're a student and you're getting funded from the university in the form of a research grant that's inside the university, then the university does want to assert its intellectual property rights. Having said that, you can still benefit from licensing, and we're very weak in the area of licensing at Fairfield, but other universities are strong. So it all depends on where you're at. Fairfield University is primarily a teaching school, not a research school, and that's the reason for that.
Understood. Is there any way of getting around? I'm thinking of my own situation. If I raise some money for particular type of investments, and Doug, you and I have talked about this, it's at a limited length. Any way of getting around making portfolio decisions? We're probably hiring somebody with Series 7.
Well, you can
Actually,
you can hire an investment advisor to advise your fund.
Okay. Yeah, use that as,
there are these YouTube videos done by one fellow who claims that if you're not taking a management fee, that it makes a difference in terms of what's required of you in terms of regulations. But if you want the management fee, then you need to pass something like a Series 67 or 6. I forget what he called it, but I'm not real clear on that. Kim, you might.
Yeah,
Who was it? Do you remember the guy's name?
Yeah, Pendleton something or other.
Yeah, I'm not. I haven't seen any of his videos, so I don't know.
Okay.
Yeah, if I were to get into that type of thing as a fund manager, maybe just as a shadow backup, I guess I'd have to have somebody who's a registered investment advisor, but I would want to absolutely call all the investment shots.
Yeah, you may or may not be able to do that because of the investor advisor rules, and you're going to have to be you're going to want to consult an attorney that deals with investment advisor registration, which I could refer you to if that's something you want to pursue.
Yeah.
So if you want that, if you're interested, again, just email me at kim@syndicationattorneys.com and ask me your question. I do have the referral information for somebody who does that.
Okay.
Mm-hmm.
Yeah, we'd just be using the guy more like as a trading desk. You decide what you're going to do, and just goes into
Well,
the
or
desk.
you may just have to go get your own license. It's not that hard.
Well, I thought it was quite hard. You had to work for a registered brokerage house to be able to
You're
do that.
thinking of a Series 7.
Yeah, that's different. That's a registered representative.
Okay.
So you're talking about becoming a registered investment advisor, where
Okay.
you can take a fee for investing other people's money, and you're going to be. So what it is that you have to have the license to be cast in the role of a fiduciary, who is acting on behalf of your investors over and above your own interests.
Mm-hmm.
And so you're getting to know your investors, to know their risk tolerance, their suitability, their profile, so that you're picking investments that are suitable for them.
And that would be through the SEC.
And it depends. The rules for registered investment advisors are very convoluted. There are, certain, you have to have over a certain dollar amount of assets under management before you can get SEC registered. Prior to getting SEC registered, you can get state registered. Some states don't have any requirements at all. Some states do, and the state depends on where you're located. But then if you're bringing in investors from outside those states, you've got to know what does that mean. So you just got to you need an attorney that deals in that area specifically. to help you navigate all that. And usually the way that we handle things like that is people come to us and we say, what do you want to do? You tell me, don't tell me what, what license you need, what exemption you want to do, what all that. You just tell me what you want to do and I'll figure out which way makes the most sense for you to do it. So, and that's what you want, is you want to say, look, I want to be able to do this. I want to invest in these things. I want to raise money for this. I want to call the shots. What license do I need, if any, to do this?
Okay, I understand. You want to structure the whole thing, even before
Yeah.
market. Yeah, that you sort of went by that before. You want to structure it, what type of corp, and then you figure out what's needed in terms
Well, not
of.
only what type of corp, but what kind of investments, because, nobody's going to give you money until they know what kind of investments, and your criteria could be, medical startups or, tech startups or, what are you investing in? Because some people are going to say, I'll invest in, value add real estate, but I'm not going to invest in development projects because I perceive that to be a bigger risk. And so it's the same thing with you. Maybe people think .coms are the, wave of the past and they don't want to invest in that. So you've got to define it. And the more tightly you define what you're going to invest in, the more success you'll have raising the money. People won't invest in what I call kitchen sink offerings, right? Where you can invest in anything you want, including the kitchen sink. And they don't have any say whatsoever. They're not going to give you their money to invest in that.
Well, in terms of the industries, it would be defined, but in terms of the particular investments, some might be public, some might be startups, but it would be focused on a particular idea.
Yeah, and I think that's okay, because I think people who agree with that idea are going to be interested in investing in that. Just the same as some people won't invest in cannabis because
Right.
they don't believe in that, or
Okay.
they've dealt with that in the past. So you've got to just define what it is you are investing in, what it is you're not investing in. That's what you put into that investment summary. Here's my investment model and my plan.
Yeah, that
And you try to keep it broad enough that you don't tie your hands so you can't do anything, or if the market changes, it doesn't work anymore. But you also don't make it so broad that people are like, it seems like
Right.
he can do whatever he wants with my money. I don't like that.
Right. Yeah, that answers it well. It's not kitchen sink, but it's focused, but it could be startups and it could be public companies.
Sure. And if you're focused in a particular industry, I think that could resonate well. And so part of your investment summary is talking about that industry. And then you're going to create some marketing material surrounding that, maybe a website, a pitch deck, why this industry? Why did I pick this industry? Because, here's what it's done in the past. Here's where I see it going in the future. Here's where it's at today.
Exactly. That really answers the question. Thank you.
You're welcome. Mm-hmm.
So I think we're wrapping up. I just wanted to announce our next speaker is going to be Bill Erickson, and his title of his talk is called The DeFi Revolution, Reprogramming Money and Finance. Bill has started an exchange in London, which allows you to exchange Bitcoin for London real estate. So one extraordinarily volatile instrument for another, which I guess people like or something or other. I'm not sure exactly why or why. Maybe you can get Dogecoin too. Now you can find an application for Dogecoin. I don't think anyone knows how to exchange that for anything yet. So Kim, I want to thank you very much for a great presentation. That was terrific. And sorry for the low turnout there, but at least we had some good questions and this was a fantastic presentation.
Well, and if you'll send us a copy of the presentation, then we'll post it on our website, and
great.
Maybe you can send it back out to your audience.
Yeah,
sounds good.
Presentation was great with a detailed and deep industry that it was summarized very well and focused on things well.
Thank you so much, Bill.
All right. Well, have a good night, everybody.
Okay.
And Kim will be in touch.
All right. Thank you. Bye-bye.
Bye-bye.
Bye, guys.